Court records are meant to show how justice is delivered, but not every decision is spoken aloud. Some outcomes are shaped by rulings and orders issued in open court. Others are shaped by what a person agrees to quietly, long before a ruling is ever announced. These are those cases. This is what happened before the gavel fell.
Daniel Reyes is told there will be a meeting later that afternoon. The message is brief and comes without explanation. It does not say who requested it or why it is happening now. It only says that attendance is expected and that the meeting is not a hearing. Daniel has learned to pay attention to words like that. He is escorted from the holding area and led through a section of the building he has never seen before, a corridor that feels deliberately removed from the public-facing parts of the courthouse. There are no benches, no posted notices, and no sound except for their footsteps echoing against the walls. The absence of noise makes the walk feel longer than it probably is. At the end of the corridor is a plain door with no markings. When it opens, Daniel finds himself in a conference room that looks more like an administrative office than a place where decisions about freedom are supposed to happen. There is no seal on the wall, no flags, no elevated bench, just a long table, 3 chairs, and a folder placed precisely at the center, aligned with the edge as if someone measured the distance. 2 people are already seated when Daniel enters. They stand politely, introduce themselves only by last name, and motion for him to sit. Neither identifies their role in the proceeding, and Daniel does not ask. Experience has taught him that titles rarely matter in rooms like this. He is told, calmly and more than once, that the meeting is informal, that nothing decided here will technically be considered a ruling, that the purpose is simply to discuss next steps and ensure that the case continues smoothly. The word smoothly is emphasized. They begin by confirming basic information: his full name, his date of birth, his current address, whether he understands why he has been brought into the room. Daniel answers each question without hesitation, even as he senses that the confirmations are not for accuracy, but for documentation. One of them explains that the court has reviewed recent testimony, procedural history, and documentation associated with the case. Certain concerns have been noted. The phrase is delivered neutrally, without accusation or urgency. Daniel notices that no one says who raised the concerns. The folder is slid toward him, not abruptly and not with ceremony, but with a kind of practiced restraint that suggests this moment has been rehearsed. He opens it. The document inside is titled Acknowledgement of Interim Compliance. The language is dense but careful, written in a tone that avoids blame while still asserting authority. It states that Daniel understands the court's concerns, that he agrees to participate in recommended steps while the case proceeds, and that he waives objection to temporary measures intended to stabilize the situation. The word temporary appears repeatedly, each time paired with assurances of fairness. As Daniel reads, he begins to recognize the language. Phrases lifted directly from the transcript. Concepts introduced as findings. Emotional reliance. Boundary uncertainty. Risk assessment. The document does not accuse him of wrongdoing, but it clearly assumes alignment with the court's interpretation of events. Daniel looks up and asks whether the acknowledgement is required. There is a brief pause before one of them answers. He is told that participation is voluntary, but that cooperation will be noted as the case moves forward. The word noted lands heavily. He asks what happens if he signs. They explain that signing demonstrates insight, responsibility, and a willingness to engage constructively. It allows the court to view him as cooperative and invested in resolution. It helps everyone involved. They do not specify who everyone is. Then Daniel asks the question he already knows he shouldn't ask. What happens if he doesn't sign? The response is careful, measured, delivered without threat. They explain that proceedings will continue as scheduled, that custody status may be reviewed again, that future cooperation will be evaluated in light of the court's concerns. No one raises their voice. No one pressures him directly, but the meaning is clear. Daniel looks back down at the document. He notices that nowhere does it ask him to admit fault. Nowhere does it require him to confess or concede wrongdoing. It only requires that he acknowledge the court's perspective and agree to act in accordance with it. He realizes then that acknowledgement is the same as acceptance. A pen is placed on the table in front of him. One of them explains that this does not resolve the case and does not prevent future review. It simply allows the court to move forward efficiently while ensuring stability. The phrase "move forward" is used again. Daniel asks whether his attorney should review the document. They say of course, and encourage it. Then they add, almost as an aside, that delay may affect how the court interprets his willingness to cooperate. The statement is not framed as a warning, but it functions as one. Daniel rereads the final paragraph. Participation does not constitute an admission of wrongdoing. He understands now that while it may not be an admission, it is a form of compliance, and compliance becomes part of the record whether or not it is labeled as such. The room grows quiet. No one rushes him. No one tells him to wait. The meeting does not formally end. The pen remains where it is. Later, the paperwork will show that Daniel Reyes was offered an opportunity to participate voluntarily in interim measures designed to address the court's concerns. It will show that cooperation was encouraged and that no coercion occurred. It will not show how narrow the choice actually was. The court does not need his signature to proceed. It only needs to know whether he objects. Before the gavel fell.